Hi, I'm Ashley, and the court case that I chose was Mills versus Board of Education of District of Columbia, 1972. This was one of two important federal trial court rulings that helped to lay the foundation that eventually led to the passage of Section 504 of the Rehabilitation Act of 1973 and the Education for All Handicapped Children Act. Prior to 1975 and the enactment of these laws, many schools did not offer special education for students with disabilities. Millions of students were denied appropriate services or excluded from public education entirely. Mills was a class action suit that was brought on behalf of 7 children and other similar situated students who resided in the District of Columbia. The students in the plaintiff case had been identified as having behavioral problems or being mentally retarded, emotionally disturbed, and/or hyperactive. All of the students had been excluded from school or denied educational services that would have addressed the needs that arose from their identified disabilities. Although, of all the named minor plaintiffs are identified as Negroes, the class they represent is not limited by their race. They sue on behalf of the representative of all District of Columbia residents of school age who are eligible for a free and public education. Prior to the beginning of the 1971-1972 school year, minor plaintiffs, through their representatives, sought to obtain publicly supported education, and certain of them were assured by the school authorities that they would be placed in programs of publicly supported education, and others would be recommended for special tuition grants at private schools. However, none of the plaintiff children were placed for the 1971 fall term, and they continued to be entirely excluded from all publicly supported education. The problem of providing special education for exceptional children is one of the major proportions in the District of Columbia. The precise number of such children cannot be stated because the district has continuously failed to comply with Section 31-208 of the District of Columbia Code, which requires a census of all children aged 3 to 18 in the district to be taken. The defendants are the Board of Education of the District of Columbia and its members, the Superintendent of Schools for the District of Columbia, and subordinate school officials, the Commissioner of the District of Columbia, and certain subordinate officials in the District of Columbia. After a hard decision, the Federal District Court in the District of Columbia first made clear that the deprivation suffered by the children clearly violated their right to a public school education under the laws of District of Columbia. Quoting liberally from Brown v. Brown of Education of Topeka, 1954, the court likened the treatment of the plaintiff students to the segregation outlawed by the Supreme Court in Brown. The court reasoned that because the children would have been entitled under the school code in the District of Columbia to attend free public schools, each child had the right to such an education. The court explained that the school board's failure to meet its mandate could not be excused by its argument that there were insufficient funds available to pay for the services that the children needed. The court added that if there were not enough funds available to provide all of the needed programming, then the board had to do its best to apportion the monies in such a way to ensure that no child was denied the opportunity to benefit from a public school education. The court pointed out that the inadequacies present in the school system, whether caused by insufficient funding or poor administration, could not be allowed to impact more heavily on students with disabilities. To this end, the court ordered the board to adopt a detailed remedial plan in order to ensure that the children received the right to equal protection under the law. The court order included a provision mandating a free public education for each child with a disability, documentation that the individual special education services that would be necessary for each child who is identified as having a disability, the development of due process procedures when students face suspensions or expulsions from school, the creation of procedures that granted parents the right to challenge the system if they disagreed with any aspect of the placement of their children, and a requirement that children suspected of having disabilities be identified and evaluated. I agree 100% with the decision in this ruling. Every student deserves the same education whether they have a disability or not. I think the money should be distributed equally between the students in general education and students in special education. My sources were the Special Education Law book by Latham, and Malowitz, and I read some articles on a site, Kids Together, that is a nonprofit organization that has dealings with special education court cases.